Rise. Court of Appeal in the 4th and 5th District of the State of Florida is now in session. The Honorable F. Rand Wallace, Judge presiding. All persons have business in the court run here. Attention will be heard. United States of America.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. Once again, my name is Rand Wallace. Thank you for that introduction, Marshall. And to my right and your left, joining me on this panel is Judge Jim Edwards from Seminole County. And on my left and your right, Judge John McIver from Duval County. We have one case on the docket. It's Lawler versus Bishop. Before we get started, just ask everybody in the courtroom to please silence any devices that may make unsuspecting noise so that it doesn't disrupt the attorneys in their presentation. I will assume 5 minutes for rebuttal from the appellant unless you advise me otherwise. And other than that, you're free to proceed.
May it please the court.
Morning.
Summer Horton on behalf of appellant Lindy Lawler, and I apologize, I'm a little under the weather today. We're here today pursuant to a September 2nd, 2020 consent final judgment. And within that judgment of divorce, the parties agreed to shared parental time sharing and shared parental responsibility, and that the mother should have majority timeshare. Mother has 255 overnights, father has 110. The appellee, father, lives out of state in Georgia, and during the school year, which is the relevant time that is subject to this appeal, the father is entitled to every other weekend's timeshare and a dinner date, if you'll have that terminology, once a week. We attended an evidentiary hearing in this matter in April of 2025.
Counsel, we're very familiar with the facts. If you want to go ahead and move into your argument, feel free.
Absolutely. At the hearing, the court issued an order on April 22nd, 2025, ordering that the minor child attend public school for the 2025-2026 school year. In our brief, we made 10 legal arguments. I'm going to focus predominantly on 3 of them. It's our position that the trial court abused its discretion when it ordered the minor child to attend public school rather than designating one of the parents to make the educational decision for the child. In addition, by the court deciding that the child should attend public school, the court essentially modified the parenting plan. It changed the status quo, and it took away the rights of the parents to make the educational decisions on behalf of the child.
Counsel, don't our cases all say where there's shared parental responsibility and the parents cannot reach a decision on a major decision, which y'all's consent judgment says education of the child is a major decision, it's submitted to the court who shall resolve the impasse based on the best interest of the child. Is that your understanding of the law in the 5th District?
That is my understanding of the law.
And here, it was submitted to the trial court, and the trial court went through, listened, heard, changed from a 15-minute hearing to a hearing that lasted a little over an hour.
That's correct.
And issued a very detailed order that basically said it's a close contest, close issue, but mom has not carried her burden to basically change the status quo. Is that correct?
That is what the order says, correct.
Okay.
I believe, and if the conclusion, in the conclusion section on page 8, the court says specifically that the mother didn't meet her burden to deviate from the current parenting plan. That's not what we were asking. The mother was asking for the court to enforce the language in the parenting plan, to clarify and enforce, not to modify. By the court going one step further than what Your Honor pointed out, presents the conflict to the court, and the court resolve it using the best interest of the child standard. Under the law that I'll go through in a minute, the court was supposed to designate a parent to make the educational decision. When the court
Which case from the 5th District Court of Appeal says that?
I couldn't find one in the 5th District Court of Appeals.
Because there's not one, I don't think.
Right, I have,
Gurencher versus Mills and Dixon versus Dixon both say you submit it to the judge goes through the issues and the factors and everything else and decides what's in the best interest of the child, correct?
correct.
I mean, here, I understand the mother's argument in terms of she does have the day-to-day responsibility, she does everything for the school, I get that. And if your consent judgment didn't say it was specifically as to education, I really understand your argument and the equities and everything else. I mean, I get it. Where mom has all the responsibility, mom ought to get a little extra choice, but that's not what the parenting plan says. And that, to me, that's the hurdle I don't see you getting over, and I don't think the trial judge saw you getting over that either.
So paragraph 5A in the consent final judgment, I agree, Your Honor, says it's in the best interest of the child that the parties have shared parental responsibilities and confer to make all decisions pertaining to the child. Major decisions is defined to include educational. The next paragraph, paragraph 5B, states the same thing, but if you look back at paragraph 5A, I believe it's the last sentence, it says, each parent shall make decisions regarding the day-to-day care and control of the child while that child resides with or is with that parent.
Right, but the consent decree, consent judgment and the parenting plan has major decisions, education. Day-to-day decisions must mean something else.
It's in the same paragraph. I believe it says
That's fine, but that's a day-to-day decision.
But if you look at it as a whole, the mother has everyday time sharing during the school year.
Like I say, I understand the equities and the reason behind it and all the rest of it. I don't disagree that if you didn't have the consent judgment here, I'd be surprised if mom didn't get to make the choice here, given that she's got the primary custody and is very involved in the educational upbringing of the child and takes the kids to school and all the rest of that. But in that paragraph, it says, major decision, education of child, shared responsibility. In our cases, say, if there's an impasse, it goes to the judge decides, not the judge picks a parent and rewrites the parenting plan so that mom has unilateral decision on education. That's basically what you're asking for.
Yes and no. We're not asking for the trial court to modify the parenting plan. We were asking the trial court to enforce that particular term.
If
And-
there was a question about a significant medical procedure that needed to happen, and that significant medical procedure were to happen probably during the time the children were with the mother, would the fact that it happened during the time that it was that the children were with the mother transfer that from a major decision to a day-to-day decision?
It depends if it was, and I believe that there was something carved out in the parenting plan, but I believe there was exceptions for emergency situations dealing with medical that says the parent that has the child.
Right. No, you're adding a little bit to my hypothetical here. I'm not talking about an emergency situation or something that has to happen or something that's arisen. Mom has to take a child to the emergency room. That's what has to happen, of course. We're talking about a major life decision that is typically planned ahead of time, is discussed amongst parents, and a decision is made whether this is the best course to take or not to take. Following your logic on the educational decision, that would seem to follow that mom would just get to make those medical decisions because the child is with the mom during the time when they would be scheduled to visit the doctor. Do you follow the logic? And can you tell me why and can you tell me why my analogy is wrong?
I think that that's the issue that's today, whether you're applying to medical or education, is when there's a situation like this. And again, I believe that the case law and Malha and the other cases provide that when the decision is presented to the trial court is not supposed to make the decision for the parents. The court is supposed to appoint a parent to make that decision when they're at a stalemate.
But how is that not rewriting the parenting plan, which requires a supplemental petition? I mean, it's a different procedure. And again, I'm not saying whether you would win or lose if you went down that road, but You can't do it by motion, and in fact, in the consent final judgment, the parties agreed that any significant change that wasn't agreed on would require a supplemental petition. You didn't file a supplemental petition. You filed a motion and asked for a 15-minute hearing.
Right, we asked the court to enforce that one particular provision that was in the 5A.
How do you get to go through a parenting plan and pick out one and ignore the other that's more specific?
We didn't ask the court to ignore the other. I agree that the overall umbrella says shared parental responsibility to everything. And then the next factor or sentence in that paragraph says that the parent that has day-to-day custody with the child should make the decisions affecting that.
Well, so then just wipe out shared responsibility. Whoever has the kid that day can do anything that parent wants, is what you're saying.
I don't think-
That's not what your consent judgment says, and that's not what the parenting plan is.
It says that the mom has majority time shared
I understand that.
during the school year.
I understand that. And like I said, I don't disagree with, the equity or whatever it was if you didn't have this consent final judgment, but you have a consent judgment, which is like a contract, an agreed upon parenting plan, and you say major decisions like education we'll work with together. And again, if you have a case from the 5th DCA that says anything other than shared responsibility, impasse, goes to the court takes into consideration what the court takes into consideration under the statute, and then using the best interest of the child comes to a decision. And that's what happened here, right?
Right, and I agree with the first analysis, is that when the parents are at an impasse pursuant to Lane and its progeny and other case law, that the decision is brought to the court, and the court applies the best interest of the child standard. But where I disagree is how the court resolves the issue. And I was unable to find a case in the 5th DCA that says that the trial court has the authority to take that decision away from the parents and make it for them. Rather, there was case law.
How does a court, what case in the 5th District says otherwise?
Right, I just said that I was unable
Then
to.
the 5th District say the court makes the decision, right?
The court makes the decision by either modification petition, changing the terms of the status quo, or enforcing the terms by appointing one of the parents to make the decision. We didn't go the modification route, we went the enforcement route. We didn't ask the court to modify the parenting plan, but I believe by the court taking that decision away from the parents, it modified the plan. There's nothing in 6113, and there was nothing in the parenting plan that says when the parents are at a stalemate or if they can't agree, that the court takes that decision-making authority away from them and makes the decision themselves.
Did Lane versus Lane appoint one parent to make the decision?
Yes, Your Honor. In Lane versus Lane, which is similar to our case, the court granted the father's motion to enroll the children into school, into the private Catholic Christian school.
Right, and here, but it didn't say, Dad, you can do whatever you want, did it? The judge says, I'm looking at these two schools, and here's what we're going to do, right?
Right, and the
So the
judge,
judge made the decision there, but he said, here's the issues, here's what we're going to do here, going to go to this school. Same thing in some of these other ones where, Dixon, again, the court made the decision, didn't it?
it's the same thing. Rather than the court saying your child is going to attend these schools, the court gave the authority to the parents to enroll the child in this school. There's case law in many of the cases that are submitted in our briefs where the court said the child has to attend this learning academy or the child has to attend this public school were reversed due to the holding in Martinez versus Martinez. It is a first DCA case, but that case made it clear that the first DCA declined to construe 6113 to give the trial court the authority to direct which school the child should attend. Rather, that authority should have been delegated to a parent to make that decision.
Ms. Horton, was
Yes.
there ever a reason or any evidence given to the trial judge how attending the private school was in the best interest of the child?
Yes, Your Honor. The mother testified that the child's sister would be attending the school as well, and that it would create a little bit of friction or inconvenience to have the two siblings at two different schools. In addition, the mother testified that the school was smaller, had an intensive reading program. Both of the schools, the public school and the private school, were A-rated, and that the...
Rated by different organizations, correct?
Correct, and I think...
Wasn't one A+ and one was A-?
The public school was A+, the private school, I believe, was an A-, and the court stated those findings in its order, but also recognized that there was no algorithm or anything to substantiate how we came to those conclusions. But regardless, both the schools were A-rated. I believe that the court put a lot of emphasis on the fact that 3 of the children's friends were attending the public school and that there were additional sports and extracurricular activities, whereas the mom focused on the private school being faith-based. Religion is important to them, a Christian faith-based school that focuses that on their education, as well as having an intensive reading program and academic program to prepare the child for college, coupled with the fact that there's also community involvement where you don't get that in public school. So when you go through the transcript and the best interest factors, I believe that there was a compelling reason, and there is evidence to show from the record that it is in the best interest of the child to attend.
Anybody put on evidence that being in a class of, I think it was estimated that there was 100 students total for K through 8, so that, you know, if everything worked out equally, it'd be about 10 or 12 kids per class. Did anybody put in a study that you do a lot better with 10 or 12 kids rather than the other one? I think the teacher ratio was 16-1, so say 16 kids instead of 12?
No, but respectfully, I think the class sizes were the same, even though the private school had a smaller number of overall students versus the public school. I think the classes were the same.
If the classes are the same, how does it matter to go to one school rather than the other?
Because of the quality of the education, the focus on the reading.
What was put in terms of the quality of the education?
The mother testified regarding the intensive program regarding reading and the strong focus on a rigorous schedule that prepares the child for college.
And I'm going to stop because I'm getting into your time here, so.
I'm going to reserve the rest for rebuttal, if I may.
You may.
Good morning, Your Honors. May I please the court? I'm Michael Korn of Korn & Zemer in Jacksonville. I represent the appellee, the father, Tim Bishop. The court's questions really illuminate the inherent problems with the appellant's case. Despite counsel's attempt to dance around this court's established precedent, starting with Gensiker, I hope I pronounced that correctly, and Dixon, then manifested by another district's case in Lane, there's no doubt that when a parenting plan, as here in Section 5A of the consent final judgment, states that the parents are to make all major decisions jointly, specifically enumerating educational decisions as one of those types of decisions, and the parties cannot agree, then it goes to the trial court. The trial court then considers the best interest of the child based on the factors set forth in 6113. That's exactly what the judge did here. He went through each of the factors that were relevant. Counsel didn't mention this morning, but in their brief, she says, well, the court didn't consider all of the factors. Well, the court went through every factor and said, well, some of these factors obviously don't apply to this decision. I'm going to focus on the ones that do. And the court was very sensitive in its decision-making and its methodology in handling this. As Judge Edwards pointed out, and the record simply reflects, the mother wanted a 15-minute hearing. The judge gave her 30, expanded it to 73 minutes at the end of the day, and both parties did testify. The court, in fact, even said, look, I know that you are under some kind of a time constraint because of potential enrollment issues, which were particularly relevant for the 25-26 school year. So if you have anything else you'd like to present, send it to me in 24 hours and I'll consider it. The mother didn't avail herself of that. The court then entered its order. After that order gets entered, the mother files a plethora of motions. Motions for rehearing, motions to reopen, motion to allow the child to testify. And in essence, what the mother really wants is, in the guise of a so-called urgent emergency motion, to usurp the requirements of the parenting plan, to do a backdoor petition modification where no petition was filed and no full-blown hearing or litigation occurred, and simply evades the applicable law of this district, well-founded, that says, simply put, the trial judge is the one who has to make the decision when the parents can't, based on the standards of review. Here, there's certainly competent substantial evidence that supports why the father believed legitimately that this academy in St. Augustine, small, insular, not as highly rated, not as comprehensive, both in extracurriculars and otherwise, was simply not a good fit for their daughter.
Counsel, you would agree that there was competent, substantial evidence in the record that would have supported the judge had the judge gone for the mother, wouldn't you?
Well, it's hard to say. You know, competent, substantial evidence is kind of a moving target depending on who's, who prevailed. I believe the competent, substantial evidence judge was that, precisely as I just mentioned, what the father testified to. But ultimately, it's like in any case where the fact finder has to hear testimony, consider the positions of the parties, and make a decision. And that's what this judge did here. Whether or not there was competent evidence where mom says, well, I think it's better. Why? Well, because private school is better than public schools. Well, you know, some people may have that opinion. Many don't. That's not empirical evidence. That's at best speculative opinion. So to your question, if the court had accepted the mother's position and basically said, yep, in all instances, private school is better than public school, you know, you could make an argument that it would be more difficult to meet a burden of proof on appeal. But that's not what we have here. We simply just don't have that. There's just rank speculation as to what might happen. The faith-based argument that counsel alluded to during her remarks and in her brief is, in our view, respectfully, a red herring. This was not a case of an issue of whether there was a preference for a secular versus a religious-based school. If this was such an important issue to the mother, why was the child in the public elementary school all this time, and only when we're getting up to the middle school grade, now all of a sudden this is an issue? Here, there is substantial competent evidence, Judge. The father presented it. The court considered it.
Even if there had been competent evidence on the other side, it's still up to the judge to make a decision, isn't it?
Absolutely, and that's what this judge did. And the judge, as I said before, I think the judge gave a very thoughtful and sensitive analysis to this. He said, look, I believe both of these parents are acting in what they believe to be good faith. I believe that the parents think in their minds that what they are advocating here is for this child's best interest. And he says, and it's a close call. It wasn't a slam dunk for one party or the other party, but that's what trial judges do every day. They make close calls. And the fact that the judge specifically stated in his order that this was a close call doesn't in any way erode the ability of this court to assess whether that was an abuse of discretion. Clearly, this court, it's a very sensitive analysis, looking not to what mom wanted and whether it would be convenient to have the stepsister there at the same school or not what dad wanted, but what was in the best interest of the child. And that's what judges do every day, and that's what we ask them to do when they exercise broad discretion in these types of matters. I would say that, and I think the court understands this, but just so I can make sure, counsel's argument that we weren't really trying to modify anything, we were just enforcing the parenting plan, that is backwards. That's precisely what they were trying to do. Enforcing the parenting plan is exactly what ultimately happened. The procedure that was established in Gensiker and Dixon in this court specifically says if the parties disagree, the issue is presented to the trial judge. The trial judge considers all the factors, weighing what is in fact the best interest of the child. And here, the trial judge made, I think, a very important and ultimately sustainable ruling, which was it was the stability for this child that, in his view, brought it over to where the father's position prevailed. There's always, in every instance, when a child is transitioning from elementary school to a middle school environment, there's always going to be some issues. But the court specifically focused on stability as one of the things as he was analyzing each of the statutory factors in 6113, said that really, in my opinion, based on what I've heard, seals the deal for not having the child go to this little academy down in St. Augustine, but to go to Passetti Bay Middle School, an excellently rated school in St. Johns County. The fact that the child's friends were going there, marginal perhaps of relevance or not, but it does also factor to the issue of stability too. You know, if you're going in from a smaller elementary school to a larger middle school, it's good to have, I guess, a couple of familiar faces and friends that are, you know, either your neighborhood buddies or people from, you know, your school environment. So the court focused on that too and considered that, again, sensitively and moved forward to a decision that's embodied by the order and was, in fact, exactly what this court asks trial judges to do, the procedure that was set forth. And this is not an absentee father, to the extent that there was any illusions.
I don't think there's anything in the record to suggest bad faith on the part of either party, so I don't think you have to reinforce that part.
Thank you, Judge. I appreciate that. I just wanted to make sure. He, in fact, even moved closer. They were divorced in Gwinnett County, I believe, in Georgia. When Mom decides to move to Florida, the father relocates his law practice to South Georgia so he can be closer to exercise his time sharing. So this was not an issue where the parenting plan is being enforced. What Mom was trying to do was to evade the parenting plan, and as Judge Edwards observed before, to basically usurp unilateral control over a major decision such as education.
How much discretion does the judge have when it comes to the independent factors? If the judge were to review those factors and, say, place all of the weight on one of them, let's say you were sitting on opposite sides of the courtroom today. The judge put all of the weight on the factor of the religious preference of the school. He said, you know what? Yes, this private school is better. It's not. You're not dealing with the government in doing it. You have some control over the educational system more than you would if you were dealing with the bureaucracy. If he had put all the weight just into that, would he be abusing his discretion in that case?
I'm not sure I can fully answer that question, Judge, without knowing exactly what the evidence would have been from which the court was going to make that ultimate assessment.
Again, let's
There is
just
no evidence in
let's
this
just
case
let's just
about
presume that there's competent substantial evidence, but there's only competent substantial evidence for one factor. Would that be an abuse of discretion for the judge to say, well, I'm putting all the weight on that one factor?
If all of the other factors were either not relevant or in equipoise, and that was the only factor that was involved, I suppose one could argue, if there was competent evidence to support it, that was how the court properly exercised its discretion. But of course, that hypothetical is not.
Does the judge have the discretion to decide which factors are more important than other factors?
I think the court may, I think he does. And he did here by addressing each of the factors and either finding there was no evidence presented on them, or they weren't relevant because some of those are kind of the standard time-sharing considerations that didn't bear on the educational decision. So the fact that each of the 20-some-odd factors in 6113 sub 2, didn't apply or weren't triggered doesn't mean that any one factor necessarily has to carry the day. The court had to consider all of the factors as a whole. And that's exactly what happened in this case. So, theoretically, if you had 20 factors and 19 of them are irrelevant or not applicable or not litigated or not the subject of evidence or testimony, and there's only one factor, I suppose under that hypothetical, you'd say, well, that's the factor that the court could consider in exercising its discretion. But that's, again, not what we have here. Simply put, that's just not what we have here. Simply put, this case was properly defended by the dad, properly considered by the court, and the court bent over backwards to consider it on a timely basis. And we're now here, these hearings occurred in April of this year, 2025. The order comes down in May. The testimony says that these admissions, these enrollments, are not, they don't carry over. You got to do it every year. So I'm not even sure what the remedy at this point is, other than what counsel really suggested what she wanted, both in her papers and even more plainly this morning, which was she wants unilateral control for the mom to be able to make the decision and that the dad has no voice. The parent plan is a contract. Contracts ought not to be avoided unless a good and sufficient reason. That's why petitions to modify are required, not an emergency motion filed literally on the eve of a decision that needed to be made, when this issue, interestingly enough, had been raised as early as the fall of last year. And the emails that the mom put into evidence show the exchanges between these parents. And the father was, after he investigated the merits or lack of merits of the various schools in question, he said, look, I'm not comfortable with this place. I might have been more comfortable with another private parochial school, but she didn't get admitted there for whatever reason, whether the size of the school or it was not class size. I think it was called Christ Church. But here, we wait till the last minute. We do a hurry up. Why the mom thought that a 15-minute hearing was going to be sufficient to accomplish this, short of just exactly what was admitted from this podium this morning, which was, I've got the majority time sharing. I want unilateral control. Why is there any dispute about it? That's not what the law says, not what the law of this court says, and it's not what makes sense. For these reasons, the trial court appropriately exercised its discretion based on the competent evidence they had before it. There was no issues of due process. There were no issues to the extent that are raised in the brief that were properly preserved, because they weren't. The religious issue was not an issue until rehearing really comes up. For these reasons, unless the court has any other questions or any other things you'd like to address, I'd like to stand down and urge you to affirm this ruling. Thank you.
Ms. Horton, you have just shy of 4 minutes.
Briefly, Your Honors, I wanted to go through the court ruling and touch on a few things that opposing counsel has mentioned in his statements. The court focused on 3 factors in particular in the order, and stability being one of them. The court found that that it could not find any particular advantage to move the child to private school versus public school. The court overlooked the fact that the reason the child was thriving in the grade school that she was in is partly based on the home life. The mom's involvement with the school, the mom doing the homework with the child, and the fact that it is a family unit. By the court's ultimate decision to find that there's more stability in moving a child to a larger public school that's new to the child versus a smaller private school, I believe is misplaced. I believe there would have been
Does that rise to the level of abuse of discretion, though? Getting it wrong is an abuse. Not considering it appropriate in the first place would be abuse. And it seems to me like you're saying that the judge didn't weigh the factors correctly. Your argument is that he should have weighed them more correctly, but that's an error. That's not an abuse of discretion.
I think, I agree, Your Honor, when you look at everything in total, from the order that was issued by the court, it's almost that the order was looking towards the best interest of the father, if I may, rather than the best interest of the child, to favor the father with regards to the arguments that the father made. In the order, the court points out that the mother's very involved in the child's school. She's PTO president, volunteers at the school, versus the father testified because he lives out of state. He hasn't been to the child's school more than a handful of times in the last several years. And the court pointed out that the father doesn't exercise most of his weekend timeshare during the school year, nor does he exercise his date night with the child during the school year. The court focused on this being a good problem to have, and I agree that it is, whether a child should go to private versus public. The father didn't object to the child going to private school. He objected to the school the mother chose. The father didn't object to the child going to a...
He didn't object to every school the mother chose. I mean, the Christ Church Academy, if that's the proper name, she wanted the child to go there, and he said he may have been okay with that, but I saw somewhere, I think, there just weren't any seats there.
Right, the
It's
child
all full
wasn't
up.
accepted.
Not that she didn't qualify or anything else, but he didn't say, no, you have to go to this school, but this particular school, and he has a right to have his opinion about that, doesn't he?
He does have...
She has her right to an opinion about it, and as you say, you know, you wanted court intervention, and you wanted the court to resolve the impasse, and I'm looking at 196 or page 18 of the hearing transcript. So everybody said, Judge, you resolve this impasse. And the judge did.
Right. I believe that the father's objections, based upon the fact that the public school had more sports, and based on the fact that 3 of the children's friends were going to the school, I think was misconstrued and misapplied by the judge. When you transfer that to the order, it stated in here, most of the child's friends are going to the public school. I don't think that that should have been considered as something that you weigh with regards to a child's education with going to private versus public school, the sports and the friends that go to the school. I think that just as the father's entitled to his opinion, the mother's entitled to hers, and the mother, as the majority custodial parent, is in the better position to make the decision as to the best education for the child rather than the out-of-state father and the trial court, if I may.
Thank you, Ms. Horton.
Thank you, Your Honors.
It was well argued. Thank you for your arguments, counsel, and we are adjourned.